My lord, I beg to that song. Item number 6, my lord. इसमें अपना भेका सर मैं I am to take step only. It is on the orders.
Other side, you have informed.
I have informed. It is
Heard-
orders matter.
Heard Mr. D.
6, my lord.
Lordship, I am for the respondent number 1 in item number 6.
You have any objection?
No objection.
Heard Mr. DCC Pukon, Learned Counsel for the appellant. Also heard Mr. What is your name?
My lord.
What is your name?
P Deka.
Heard Mr. P. Dekar, Learned Counsel for respondent number 1. Learned Counsel for the appellant has prayed for an adjournment on the ground of personal difficulties, to which the counsel for respondent does not oppose. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after puja vacations on a date to be fixed by registry.
All right.
May I please, your lordship? With both party consent, lordship, I beg to mention item number 18, lordship. This will have maybe taken up first week of October, lordship.
October, a date may be fixed, October 3rd or 4th.
No date. Item number 18.
18, 1
Heard Mr. P. Bora, learned counsel for the
appellant.
appellant. Also heard Mr. S. A. Bhakhtiar, learned counsel for the respondent. The counsel for the appellant has prayed for an adjournment. The prayer is allowed. Let this matter be listed in the first week of October
Obliged.
on a date to be fixed by registry.
Please, your lordships. Lordship is filing IA, my lord. On 17/9/2024, your lordship was pleased to grant us interim protection in an anticipatory bail application. There has been some error on our part in giving the address of one of the petitioners, my lord. So we filed an IA for, we will also be filing an amended cause title for that. We are seeking leave and also for rectification of that part.
Now, what do you want?
Tomorrow, my lord, it can be listed tomorrow. Deeply obliged.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 2 of the daily list, lordship. Lordship, my senior is engaged in a parted matter today. I pray that the matter will be adjourned for the day, lordship.
My lord, it may be fixed on 27th, my lord, because the trial court matter is fixed on 1st of October
27th
of this month.
Heard Miss P.
Arbor.
R. Burwa, learned counsel for the petitioner. Also heard Mr.
And for the petitioner.
Lordship, I'm for the respondents, lordship.
A. Bhattram.
Heard Mr. A. Bhatra, learned counsel for the petitioner. Also heard Miss P. Burwa, learned counsel for the respondent, who submits that R. Burwa
Arbor, lordship.
for respondent number 1, 2, and 3, who prays for an adjournment. Stop. There is allowed. Let this matter be listed again on 27th of September.
For 27th of September. File your-
Deep service.
May I please, your lordship? Item number 11, lordship. In this case, I am the petitioner, lordship. The respondent has already entered appearance. Learned friend is appearing. So, matter will fix for admission, lordship.
Heard Mr. A. Sharma,
It will be fixed after vacation, lordship.
learned counsel for the petitioner. Also heard Mr. R. Sharma, appearing for the respondent side. The appearance of the parties is complete. Let this matter be listed for admission hearing on a date
And if he is dead, fixed, lordship, after vacation.
after puja vacation on a date to be fixed by registry.
Lordship may fix it because otherwise it will be listed.
I'm not expert in fixing dates. After puja vacation, registry will fix date.
Obliged. May I please, your lordship? Item number 27. I am for the petitioner, your appellant, in respect of respondent number, sole respondent, service request has been waited. So, lordship, kindly fix another date.
You have gone through the office records.
Yes, lordship. As per office noted dated 18/9/2020.
Heard Mr.
Yes,
S. I. Akan, learned counsel for the applicant. Stop. On perusal of the office note dated
18/9/2020.
18/9/2024, it appears that service report on the respondents has not yet been received. Stop. Await further. Let this matter be listed after 4 weeks on a date to be fixed by registry.
Lordship.
So. May I please tell Lordship? My lord, this matter may be tagged with page 30, my lord. BA number 2662/2024. Is a co-accused bail petition pending and it is fixed on tomorrow, my lord. Page 30, my lord.
Okay. On request of Mr. H.R. Chaudhary, learned counsel for the petitioner, let this matter be listed. Let this matter be listed tomorrow along with
Along with BA number 2662/2024.
BA number 2662/2024 in motion column.
It was, my lord, the record was called for tomorrow. In that case, my lord.
Okay, no, we'll see tomorrow then.
My lord, obliged.
Show the presence of additional public prosecutor.
Obliged.
May it be pleases your lordship, perusing the last order dated 18/9/2024, your lordship, that the correction rectification application has been filed, your lordship, yesterday itself. Here, your lordship, a simple modification is to be needed, your
Where is the
lordship,
correction?
your lordship. That I has been filed, your lordship, yesterday.
What is the number? 294.
2946,
Okay,
your lordship.
let us take up IFS.
Yes, your lordship. That application for rectify modification, alteration of typographical error in regarding cost.
Third, Miss P. Das, learned counsel for the applicant. This in interlocutory application, this interlocutory application has been filed by the applicant in connection with transfer petition within bracket C number 79/2024, seeking to rectify some typographical errors which have crept in the transfer petition due to inadvertence. Stop. Learned counsel for the applicant has submitted that. What you want to correct?
Your lordship, instead of learned principal judge family code, it should be family code
Where?
3,
Where?
page 2. Page 2 of my IA. Instead of Guwahati, it should be the pending before the learned principal judge family code 3. That 3. Earlier
Learned
it was
counsel
not
for the.
mentioned, and then thereafter, your lordship, that
No, but first let us.
yes, page 2. Page 2.
Instead of principal judge family code number 3, what should be there?
Instead of Guwahati, it should be the pending before the learned principal judge family code 3. That 3.
No, what is the error and what you want?
Your lordship, it was earlier not mentioned the code number, your lordship, that is 3.
3
Yes,
was
your
not mentioned.
Yes, your lordship.
Others. will-
Other, your lordship, only Guwahati, in the other stated fact, your lordship, the learned first class judicial magistrate Jorhat, that this jurisdiction, earlier it was mentioned in Nagaon, and instead of Nagaon, it should be Jorhat, the district.
In which pages you want corrections?
In the cost title itself, your lordship,
Post title,
that page 2 of my transfer petition,
okay.
that jurisdiction in Nagaon, instead of Nagaon, that transfer petition is applied for the transfer to Jorhat district, not Nagaon. That I highlighted.
Learned counsel for the applicant has submitted that due to inadvertence typographical mistake in the second page of the transfer petition in the first line, the word Nagaon has been wrongly typed out instead of Jorhat. Hence, she prays that the applicant may be allowed to correct the word Nagaon by substituting the same
Jorhat.
with the word Jorhat. Stop. The prayer is allowed. The
Thereafter,
the
your
petitioner, learned counsel for the petitioner also submits that. Next,
next, your lordship, page 8 of my transfer petition,
yes,
that pendency part, your lordship, prayer part. That it was mentioned that FC case number 344 pending before
where,
the-
which line?
that
Page 8.
page 8. From during pendency onwards and thereafter. Last paragraph, your lordship. During pendency. Page 8 of transfer petition.
Yes, second paragraph.
Yes, your lordship. That
Second, second
FC
paragraph, which line?
fourth line, your lordship.
Yes,
FC case number 344/2024 pending before it was wrongly written, your lordship, that the Nagaon part, your lordship. Instead of Nagaon, it would be Jorhat. It would be Principal Judge Family Court number 3, your lordship. That earlier I had submitted the first prayer, your lordship. It will be remain same.
learned counsel for the applicant has also submitted that in page 8 of the transfer application, in paragraph number 2 at line 6, 7, line 7, 6, line 6, 6. Instead of word district judge Jorhat,
Nagaon,
no, district judge Nagaon,
it should be.
3 words, family court number 3
Three,
should be inserted.
Guwahati.
The prayer is allowed. Any,
And your lordship, last paragraph, your lordship, pertaining to paragraph 5
which page?
of my writ petition. Your lordship, page 5 itself, paragraph 5. Earlier, it was mentioned that on 6/9 for written statement, the case has been refixed on the principal judge court number 3. But your lordship, now your lordship, another date has already been pronounced, your lordship, that has fixed, your lordship, on 6/11/2024 for written statement. So instead of 6/9/2024, I would like to replace it
Learned
6/11/2024.
counsel for the applicant also submits that in page 5 of the transfer petition at paragraph number 5, last line,
Last,
the date 6/9/2024 has been inadvertently mentioned. And instead of the said date, the date 11, which date should be?
6/11/2024 for written
6/11/2024
statement.
should be there.
This has
The,
been fixed.
the prayer is allowed. The no more rectification.
No more.
The prayer is allowed. The rectifications mentioned herein above shall be done by the registry. Done by the registry, and thereafter list the transfer application again on 23rd, on Monday,
So,
on 23rd/9/2024. This interlocutory application is accordingly disposed of.
deeply obliged.
Lordship will item 4. Lordship will find the FIR at page 12.
Case diary is there.
Yes, there is, ma'am.
Page 12, Lordship may see, my lord. These are the 4 named accused. Petitioner is not a named accused, my lord.
What is the offense?
Offense, my lord, is that, my lord, so far as this, my lord, accused number 1 is concerned, the petitioner of the other case, 5.
It has been alleged that, my lord, he being the general manager of the Nirmala Tea State, he misappropriated, my lord, a huge amount of money without the knowledge of the tea garden authorities. And also, my lord, he has stolen, my lord, a huge amount of tea to the tune of 50,000 kgs. And misappropriated.
Since
along-
when you are behind the bars?
My lord, he is behind, my lord, so far as the present petition.
We
is
are
concerned,
taking,
Yes.
we are considering first.
Yes,
present.
so lordship will kindly see, my lord, he was arrested on 18/8. 19 he was produced. 18/8, my lord, today it is exactly 1 month, my lord. And my lord, his allegation against him is, lordship will find that, my lord, only one small para, page 16.
Yes.
Sri so-and-so was the supreme authority in the garden to issue biometric cards.
Which para you are reading?
Sixth para, my lord,
Sixth,
six, yes.
Okay.
Mr. So-and-so was the supreme authority in the garden to issue biometric cards. All records could not be located. However, we have found a few fresh records in which false haziras cards were swiped on a daily basis and wages paid in cash every week. The temporary man wages payment desk was managed by Nirutpal Das, there is a petitioner. He and Mr. Arpit Tiwari, who is under interim, my lord, on an anticipatory bail, used to swipe the false cards on the attendance machines, and on payment day, it was such that all the false haziras was paid from Mr. Nirutpal's desk, who in turn used to siphon off the money and pay to Mr. Pankaj Tiwari. As Pankaj Tiwari, by using his position, falsely asked to do so as per Pankaj Tiwari, otherwise Nirutpal Das would have to lose his job. And for which Nirutpal Das obeyed the direction of Pankaj Tiwari. So
You are
Nirutpal Das,
Nilotpal. You are.
yes. In fact, my lord, the informant is trying to protect him, my lord. May I read further? So Nirutpal could be the witness in the aforesaid matter. He was given massive increment and favors by Pankaj Tiwari to act on his behalf.
What
We
is
have,
the progress?
My lord, investigation is going on, my lord. Charge sheet not yet submitted, my lord. And from the here there, my lord, several witnesses examined, my lord. Here, more than, my lord, 9, 7, 8, my lord. 164 statement recorded, my lord. In 164 said regarding their involvement, my lord. How they are involved, my lord.
Now, what is your submission?
My lord, my submission is that he may not allow at this stage, my lord. I have the objection in this regard, my lord. And here, from the witnesses, it reveals that from his statement also, my lord, he done all his activities on the, my lord, as per direction of the, my lord, next, my lord, Pankaj Tiwari, my lord. And I am saying, my lord, his involvement, my lord.
No, but why do you need him?
he is in judicial custody.
My lord, his judicial custody, my lord, some of the, my lord, I have submitted some, my lord, objection, my lord. Here said that some of the documents, my lord, is yet to be verified, my lord. And huge
But
transaction was done, my lord.
But documents are already seized.
Some of the documents, my lord, yet to be
Seized.
verified, my lord.
How it will help you
My
if
lord,
he is detained behind the bars? Let him cooperate.
my lord, my objection is there, my lord.
Heard. Mr. B. Chaudhary, learned counsel for the petitioner.
B. Gogoi.
B. Gogoi, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS, 2023 has been filed by the petitioner Nilutpal, or what is your name?
Actually, Nirutpal, N-I-R-U-T.
Nirutpal Das, who has been detained behind the bars since 18/8/2024 within bracket for last 30 days in connection with Halem PS case number 46/2024 under section 120B/171E/379/420/468/471/413 of the Indian Penal Code.
413, my lord, edit later on, my lord. 413 letter.
That is not attracted to the present petition. That I can satisfy that. That relates to the accused number one, the second petitioner in the second, the petitioner in the second case. I will satisfy
The
that.
gist of the accusation in this case is that on 1st of July 2024, one Abhijit Roy, who is the director of New Manas Tea Estate, lodged a written complaint before the officer in charge of Harlem Police Station, inter alia alleging that one Pankaj Tiwari, who is the manager of the tea estate, has misappropriated money of the tea estate as well as indulged in making false document, causing huge financial loss to the tea estate. It is also alleged, next para, it is also alleged in the complaint that the present petitioner used to swipe false card of attendance on the attendance machine on the payment day, so that, and all the false hajiras were paid from the decks of the petitioner. However, it is also stated in the complaint that the petitioner used to do so under the pressure, from the co-accused Pankaj Tiwari. Stop. What is your submission, Leonard? Apart from,
My lord, apart from that, lordship will see page 16, my lord, and the last slide. The huge cash deposit in various accounts of Pankaj Tiwari, Pragya Tiwari, and Arpit Tiwari clearly indicates that there is a big scam undertaken by them. Then lordship will see, my lord, the last one, Pragya Tiwari, amount has been mentioned. Page 17, my lord, Pankaj Tiwari, Pragya Tiwari, Pankaj Tiwari, Arpit Tiwari. The name of the petitioner is not there, my lord. There is not a single allegation that he has misappropriated money.
Leonard, counsel for the petitioner has
Referring from the, my lord,
submitted that on perusal of the
Para 6.
FIR, perusal of the written complaint filed by the informant, it would be clear that the petitioner was pressurized to do what he is alleged to have done. It is also submitted by learned counsel for the petitioner that the complaint petition also shows that the account shows that huge amount of money were deposited in the account of co-accused persons. However, nothing has been alleged regarding accumulate a deposit of money in the account of present petitioner. Learned counsel for the petitioner has also submitted that the petitioner has been detained behind the bars since last 30 days, and considering the period of detention, he may be allowed to go on bail. Stop. On the other hand, learned additional public prosecutor, Mr. B. Sharma, has produced the case diary of Harlem PS case number 46/2024 and has submitted that there are incriminating materials against the petitioner in the case diary. He has opposed the grant of bail to the present petitioner on the ground that certain documents are yet to be seized and the investigation has not yet completed. However, he also submits that that the investigating officer has in the meanwhile recorded the statement of 728
164 statement of the several witnesses.
16 recorded the statement of
164,
witnesses as well as statement under section
160.
181,
My lord, 183, my lord.
181 or
183, my lord.
183 of the
ENSS, my lord. So,
BNSS. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials I have on record. Though there appears to be some incriminating materials against the petitioner in the case diary. However, it appears that the present petitioner, the allegation against the present petitioner is that he did wrong things under duress as he was threatened by the co-accused Pankaj Tiwari. Stop. Moreover, as the petitioner has already detained behind the bars for last 30 days. Hence, considering the entire aspect of the matter, this court is of opinion that the further custodial detention of the above named petitioner may not be necessary for fair completion of the investigation of Harlem PS case number 46/2024 if he cooperates in the investigation. Stop. Hence, the petitioner, above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the judicial magistrate Vishwanath. Asa.
No, my SDJM Vishwanath. It will be SDJM Vishwanath.
Why?
SDJM Gopur, I'm sorry. SDJM Gopur.
Subject to satisfaction of SDGM Gohapur. With above observation, this bail application is hereby disposed of.
Highly obliged. In the next case, my lord, the.
He
example
appears,
one.
he appears to be the.
My lord, main
But, my
culprit.
lord, he was arrested on 1/7/24. Today it is 81 days.
17?
84. The forwarding report, lordship will find that page.
No, but still
My lord.
only 9 days are there. But investigation.
No,
is-
lordship may I submit, my lord. Some few words I want to, my lord, add. Here, my lord, the main ground of rejection of the bail, my lord, in the trial court. After expiry of 60 days was that, my lord, that 413 has been added.
What
Against
is,
the
what
accused
is
number one.
413?
This is, my lord, habitual
Heavy
defaulter.
sale.
Lordship may kindly have a look at the provision. For a moment, my lord.
Oh, habitual offender.
Then the reason I will, my lord, point out, my lord, why that has been added. 413, my lord, habitually dealing in stolen property. Whoever habitually receives or deals in property which he knows or has reasons to believe to be stolen property shall be punished with imprisonment for life or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine.
Is there material against him?
My lord, that part may I point out in
My
the
lord.
FIR itself. Lordship may kindly have a look at the FIR. Just I have to point out.
Page.
Page, my lord, lordship may turn to page 26. The present, my lord, PS case is the Helen PS case. Page 26, my lord, at the very starting of the FIR. Lordship will find, my lord, in the second para. Page 26.
Yes. Yes.
Lordship will see, my lord, the third para, that it was around the month of February, March 24. The accused person number 1 has been arrested by the Jinja police in connection with Jinja PS case number 12 of 2024 for theft and selling of tea produce by making false bill salan, and in later days, the said Pankaj Tiwari, the petitioner herein, has been released on bail. My lord, this is the particular case, my lord, which they are referring to, my lord, for adding, my lord, 413. And this is a case, my lord, which has been registered. He is accused there. He is not a convict, my lord. I have a judgment to show that 413 will be attracted only when a particular person has been convicted on similar offences. Direct judgment, my lord. is there, not in this manner, my lord. And we have not disclosed, we have not suppressed it. We have stated in the, my lord, in this particular bail application that I have been granted bail. Thereafter, my lord, lordship will see in the next para, that after dismissal of Pankaj Tiwari, he went out of his personal residence by leaving his staff quarter. Assume that he is not in the T state. So position of his, my lord, committing the same, my lord, offense again in this particular T state. He has been dismissed from service before lodging of this FIR. So 413,
What is the assurance that you will
My lord.
cooperate in the
my
investigation?
lord, lordship may grant any, my lord, condition, my lord,
What
strict
condition?
condition.
My lord.
What-
He is outsider, my lord. He is from not
My lord,
from Assam, my lord.
my lord, accused number 2 and 3 also outside, my lord. They, honorable court granted them bail with the local COT, my lord. That will be, my lord, lordship may give that stringent, my lord, condition. Because, my lord, the 413 has been added. Lordship is aware, my lord, settled law 413 will come in only when a person is convicted, not by accused,
Where is the judgment?
my lord. Just to, my lord, point out.
What conditions may be imposed, Mr. Sharma?
I let the, my lord, PP, my lord, enlighten this.
What
But on
conditions?
that, my lord, I am ready to, my lord, provide any such, my lord, undertaking.
You suggest conditions?
My lord, here,
Suggest some
Yes,
conditions.
my lord.
My lord, I will-
My lord, I am ready to, my lord.
my lord, I will have to
If
think about
required,
it. my
every
lord.
month
Yeah.
I will appear if required, my lord, before the IO, if required, for a period till the search sheet is submitted, I can appear, my lord. My lord, 4 persons of the same family, my lord, have been, my lord, made accused herein. And my lord, in
No,
fact,
but there are,
My lord.
my lord, may I submit one thing,
Lordship
my lord?
appears only
What
one
has happened
statement,
is,
my
my lord,
lord.
I
One
have, on
statement I have, my
credit,
lord.
I have not made a single
No,
submission.
he is the main accused.
My lord, he is the.
Materials are
My
there,
lord, my lord.
but
he is the-
everything has been seized.
My lord.
Everything has been seized, my lord.
Seized.
Yes.
My lord.
And
There
he-
one IO objection, bill objection, file lordship appears that.
What he has
My lord.
said.
My lord, para 49, if your lordship see, my lord, that section 413 and 411 has been elaborately dealt with by
Where it is.
para
observed.
49, my lord. Para 49. Page number, internal page down below 9, my lord. There are 14 pages, 9. In the right hand side corner, my lord, the page number is there.
Which is the exact line which.
My lord,
says-
the 49, my lord, last line. Thus, a series of FIRs or a series of search sheets would not ipso facto establish habit or habitual dealing with or receiving stolen property. My lord, there are two, my lord, type of detention has been discussed here in, my lord. One is, my lord, preventive detention and one is, my lord, punitive detention. Now, my lord, at this stage, it will be, my lord, preventive detention. Preventive detention is that, my lord, so that, my lord, the present petitioner does not commit the same crime again. I have shown from the FIR, the informant has himself submitted that they have dismissed him from service. So, committing, my lord, the stealing or
How
something, my
many
lord,
days you are behind the
my
bar?
lord, from 1st of July. Today is exactly 81 days. Otherwise, my lord, considering the other section, my lord, it is 60 days, 60 days. All below 10 years.
Okay. Heard Mr. B. Gogoi, learned counsel for the petitioner. Also heard Mr. D. Sharma, learned additional public prosecutor. This application is the same hobo with the earlier. Next para.
Lordship may kindly peruse the bill objections as, my lord.
No, what are the objections?
My lord, here objection is that he is the prime accused, my lord, and said that hampered and my lord, released on bail, he may hamper to me a recovery of property which was illegally collected by him from the complainant by them. Custodial interrogation is essential. Thereafter, Ender said that he has seen the misappropriation of the money by forging official records and concealing the record relating to the accounts, my lord. Attacking using the help of person, my lord. That hailing from other states, my lord. That is also one of the one.
You have, he will have to come to the police station every week.
My lord.
My lord, Calcutta, once in a month, my lord, or whenever they ask, my lord, I will come otherwise also. Lord, she will say once in a month, or my lord,
15
whenever
days,
is
my lord,
called
within
for.
15 days. 15 days.
I will leave it to your lordship, my lord. I am not on that, my lord. Till the search sheet is submitted, of course, I will.
Till the trial.
And one thing, my lord, whatever he has stated, these are part of the FIR. my lord.
Accusation paragraph to একে থাকিব তাৰপিছত learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 81 days the only reason for his detention beyond the period of 60 days is addition of section 41, section 413
My lord.
of
IPC, my lord.
IPC, my
of
lord. All
IPC.
sections are IPC.
of
On
IP.
23/7/24. That too,
Learned
my lord.
counsel for the petitioner submits that the section 413
Page 45, my lord.
has been added against the
45.
petitioner only because he was earlier arrested in connection with Jinja
Jinja
PS case
yeah.
number 12/2024 for the accusation of theft and selling of tea produce by making false bills. However, he submits that in that case, what has happened?
My lord, he was
Charge
granted
sheet.
bail, charge sheet probably, to my knowledge, not been filed.
However, he submits that
My lord, I
in
can say
this,
definitely, my
in
lord.
the said case, the petitioner was granted bail and
Yes,
he is yet to face trial in the said.
my
case.
lord. Yes.
Now, he submits that the petitioner is ready to cooperate in the investigation and ready to abide by any condition. You have passport?
Then my lord, passport.
My lord,
Do you have passport?
my lord, Lordship may direct, my lord, if he has, he will silence.
Hmm.
Lordship may indicate that.
Okay.
I will.
On the other hand, learned additional public prosecutor has produced the case diary of Harlem PS case number. PS case number to लिखिबो. PS case number 446/2024 and has vehemently opposed the grant of bail to the present petitioner on the ground that the present petitioner is the main accused in the FIR, main accused in this case, and there are sufficient incriminating materials against him.
My lord.
He has also submitted that the investigation is yet to be completed and releasing the petitioner at this stage may
Temporal.
have a risk of tampering with
Right.
the evidence. So I have considered the submissions made by learned counsel for both the sides.
My lord, he has a passport, my lord. Lordship may direct that, my lord,
Okay.
will silence.
Learned counsel for both the sides and have perused the case diary. Stop. It appears that in this case, one of the co-accused has already been granted bail and another co-accused has been given
My lord,
protection.
Two has been granted bail. 2 and 3 has
Okay.
been granted bail.
Absolutely, sir.
Absolutely.
Anticipated bail.
Anticipatory to accused number 2 has been final granted bail by his honorable court, and my lord,
Wife of
regular
the.
bail for respondent number 3 by
Wife
his honorable.
wife of the petitioner.
Yes,
Wife of the.
since my lord, she was a housewife, so my lord, that bail was anticipatory bail.
Lastly. Granted bail and other two
2 and 3, accused number 2.
instead of one, two of the co-accused are already granted bail. It also appears that the investigation has fairly progressed and seizure of several documents have been made and statement of witnesses have been recorded by the investigating officer as well by the judicial magistrates. Stop. Considering the length of detention, before that, the petitioner has been detained behind the bars since for last 81 days. And considering the progress made in the investigation as well as the period of detention undergone by the petitioner. This court is of view that if the petitioner cooperates in the investigation, his continued detention may not be necessary for the sake of fair completion of the investigation. Stop. Hence, in view of above, the above named petitioner is allowed to go on bail of rupees 50,000 with two sureties of
One comment, sir.
with
Government.
no with two sureties of like amount with following conditions. The petitioners shall surrender his passport before the Chief Judicial Magistrate, before the SDGM Gopur. Stop. The petitioner shall not directly or indirectly make any inducement, threat, or promise to any person or persons who may be acquainted with the facts of the case, so as to dissuade such persons from disclosing such facts before the investigating officer or to the court. Stop. The petitioner shall appear before the investigating officer every 20 days, once in every 20 days for next 3 months or till the investigation is completed, whichever is earlier. With above observation, this bail application is hereby disposed of. Send back the case.
Highly obliged. Highly obliged.
Let me see the last order.
What is this?
It's a petition for condoning a delay of 64 days. Service is complete on all the opposite parties, but they are not turning up.
Heard Mr. D. Das, learned counsel for the applicant. None has appeared for the respondents, though notices were duly served on them and several opportunities were granted to the respondents to appear in this case. Stop. Therefore, this court intends to proceed with the hearing of this interlocutory application. Stop. This interlocutory application has been filed by the petitioner, by the applicant. You were the claimant.
Yes, Lord.
By the applicant, Project Rabha, alias Projit Rabha, under Section 5 of the Limitation Act 1963 for condoning the delay of 64 days in filing the connected MSc appeal, whereby the petitioner, whereby the applicant intends to impugn the judgment and order dated 13/5/2019 passed by learned member, Motor Accident Claims Tribunal, Goalpara in MSc case number 2/2013, awarding a compensation amount of rupees 3,500 only to the claimant for injuries sustained by him in a motor vehicle accident. Stop. Learned counsel, where have you
I
mentioned
have
the,
stated in paragraph 4 and 5.
what is the reason? Sickness.
Lots. Because of the disability consequence. illness.
Learned counsel for the applicant has submitted that the applicant was handicapped due to injuries sustained by him in the accident, and due to his sickness, and as he was suffering traumatic experiences he was unable to engage a counsel in due time. Stop. I have considered the submissions made by learned counsel for the applicant. It appears that the cause shown in paragraph number 4 and 5 of the application under section 5 of the Limitation Act filed by the petitioner appears to be sufficient cause explaining the delay of 64 days in preferring the connected MSc appeal. Hence, the application is hereby allowed. Hence, this interlocutory application is allowed, and the delay of 64 days in preferring the connected appeal is hereby condoned. Let the connected MSc appeal be registered and be listed again for admission after a week on a date to be fixed by registry. This interlocutory application is accordingly disposed of.
So in this case also the claimant is different, the accident is same, item 8,
Accident is same.
accident is same.
Award,
Award lordship. 3,500.
same award. And reasons for not,
Reasons of, because of his injury lordship, because of the same, same
reasons
basket.
are also same. Same order. Same order.
Only the,
Naam to change over.
and the delay is 65 days. That's-
And delay instead of 64 days, 65 days.
And the MSc case number 7 of 2019. That's
Hmm.
7 of 2017.
Case number change. over.
I'm deeply offended.
Yeah, please, your lordship. Your lordship has directed us to take steps, your lordship, on the last day. And we have taken steps, your lordship.
What is the report?
The report.
Notice issued. Sole respondent. Third, Mr.
A. Chaudhary, your lordship.
A.S. Chaudhary, learned counsel for the petitioner. On perusal of the office note dated 9/8/2024, it appears that the notices issued to the sole respondent notice issued to the sole respondent has not yet returned back. Stop, await service report. Release this matter after 2 weeks on a date to be fixed by registry.
Lordship, may kindly peruse the office order dated 17/9/24. Here, Lordship, it shows that CAPS is complete, Lordship.
17/9,
Lordship, 17/9/24, Lordship. Service is complete upon the sole respondent.
you're appearing for
Yes,
this.
we will be appearing lordship, but till date we have not filed our Wakalatnama, so some time may be granted and 4 weeks time may be granted to us for filing the opposition lordship. And petition shall be served upon us.
I'll serve a copy.
Third, Mr. A. Bhattacharya, learned counsel for the petitioner. Stop. On perusal of the office note dated 7/9/2024, it appears that the notices issued to sole respondent have been duly served. Stop. Also heard Miss
Bora.
A. Bora, who submits that she would be appearing for the sole respondent. However, she prays for some time for filing the Wakalatnama in this case, and also prays for some time for filing written objection. The prayer is allowed. You have,
Tomorrow we'll give.
the applicant, the petitioner shall furnish a copy of the transfer petition along with the annexures to the learned counsel for the respondent within 2 days from the date of this order. let this case be listed again after 4 weeks.
The dates may kindly be fixed, Lordship. Let us get a date for it.
4 weeks on a date to be fixed by registry.
Lordship.
Okay, Lordship.
May I give the list? And so far, other mode of service of notice upon the respondent is awaited.
Okay. The registered post has returned back with an endorsement.
But when otherwise, this case, lower court case is already stayed by this honorable court. Obviously, he is noticed.
No. State therefore what you are submitting.
My submission is that, my lord, naturally, my lord, when my lord, lower courts, my lord, the original case is stayed by this honorable court.
You will come to know.
Yeah, automatically, my lord, he will know, my lord. Yes, there is a proceeding in that what I could.
No, but you have to ensure that
Yes, my lord. Definitely, my lord, we have to go by procedure. My lord.
what to do. You will
But
take,
now, my lord, after vacation or in the meantime, my lord, let us see, my lord, other mode of service.
okay. Heard Mr. A. M. Barbhaya, learned counsel for the petitioner. On perusal of office note dated 17/9/2024, it appears that the notices issued to the sole respondent by registered post with AD has returned with an endorsement within inverted comma, addressee out of station for training for long time. So RTS, inverted comma service. However, the report as regards the notices sent through usual mode is still awaited. Await further. List this matter again after 4 weeks on a date to be fixed by registry.
Kindly, my lord, the interim order.
The interim shall continue till next day.
Leave to me.
My lord, both the respondent has appeared their to their wakalat number.
You have filed wakalat number.
Yes, lordship. Service has been completed. And LCR may be called. Sir.
Heard Miss, what is the name? A.
A.
Roy, learned counsel for the appellant. Also heard Miss
D. Devi.
D. Devi appearing for both. How many respondents are
Two
there?
respondents.
Both the respondents. Stop. It appears from no, stop. Let the case record of title suit number 90/2020 as well as case record of title appeal number 2/2022 be called for from the concerned courts, the registry to issue requisition for the said records. Let this matter be listed after 4 weeks for hearing.
Again.
Item 26 from Kalki. Item 26.
Taking account of the proposal that None appears for the petitioner. List this matter again on 24th, 24/9/2020. 24/9/2020.
Lordship, this actually vacates the judgment awarded, judgment awarded dated 23/6/23 for enhancement.
For enhancement,
My, yeah,
okay.
my lord, national income was taken lesser.
Heard Mr.
Yeah, Lord.
J. Laskar. Learned counsel for the appellant. Also heard Mr.
Yes, Roy.
S. Roy, appearing for
Respondent number one.
respondent number 1. This appeal under section 173 of the Motor Vehicle Act, 1988 has been filed by the appellant impugning the judgment and order dated 23/6/2023 passed in MEC case number 77/2018 by the learned member Motor Accident Claims Tribunal, Hailakandi, praying for enhancement of the awarded amount. Stop. Issue notice to the respondents as Mr.
Yes, Roy.
S. Roy has already appeared for respondent number
One.
1. No formal notice need to be issued to respondent number 1. As regards respondent number 2 and 3,
My lord, 3 already entered appearance, my lord. Her name is shown, my lord. Else. And 2 I have already struck out, my lord, on last occasion when delay condemnation was considered, my lord. Because this is an.
no, 2, this is for the first time it has come for admission.
Now, my lord, earlier.
You have strike out in the delay condemnation
My-
application.
My lord, then 2 maybe strike out, my lord. 3, she has already entered appearance. Her name.
You have to issue notice to the council. You have to notify the,
My lord, 3, her name is shown in the Wakalatnama.
but there is no order issuing notice in this case.
My lord, on last occasion.
You issue, no, they have to engage
My,
the insurance company has to engage,
my,
so notice has to go.
lord.
The learned counsel for the applicant and the appellant is directed to shall take steps for issuance of notice on respondent number 2 and 3.
2, I may be allowed to strike out. Because he's the owner of the vehicle, even in the trial, he has not contested.
And no, owner has to be there. Notice has to go. Because owner's liability insurer is indemnifying. How can you not make owner a party? Insurer is indemnifying the owner's liability only.
Right.
So you cannot choose to issue notice to respondent number 2 and 3. The petitioner, the applicant shall take steps, appellant shall take steps for issuance of notice on respondent number 2 and 3 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
My lord, LCR may be called.
Let the case record of MSC case number
77 of.
77/2018 be called for from the concerned tribunal. List accordingly.
Your Lordship, a copy of memo appending serve of now.
I'll serve.
You furnish him, I am not reflecting it.
Lordship,
Much obliged.
obliged.
My lord, my senior is on legs in court number 20, my lord. Apartheid matter is going on. Like, I pray that it may be passed over for the day. After the vacations, a date may be fixed.
My lord, in this case, evidence is expired, my lord.
Oh, my lord.
So my humble submission is, this appeal may be contested by his legal representative, so
You file an application for substitute.
petition will be, I am going to file for a petition, IA petition.
Heard
for-
Miss B.R.A. Sultana, learned counsel for the appellant. Also heard Mr. H.
A Bhatra, my lord.
A. Bhatra, learned counsel for the respondent. Learned counsel for the appellant has submitted that the appellant has already expired and the appropriate steps for substituting the legal heirs of appellant is required to be taken, for which learned counsel prays for some time. The prayer is allowed. Let this matter be listed
After 4 weeks. my
after
lord.
4 weeks.
Acceptance.
In the meanwhile, the learned counsel for the appellant may take appropriate steps as desired by her.
Highly obliged.
Lordship, appeal has been admitted on
What is
6/3/17. It is a classic case, Lordship. The suit was filed by the plaintiff, by the appellant, and suit was dismissed by the trial court on the ground of limitation. Basically on the ground of limitation, and thereafter the appellate court came to a finding that the finding arrived by the trial court regarding point of limitation is correct. And
is correct or incorrect?
not interfered with. And secondly, Lordship, they have declared title of the defendant in the appeal filed by me. Misinterpreting the evidence on record, they have came to a finding that the defendant has a right title and interest over the plot of land.
There
Where I
was any counterclaim?
No.
Oh,
Lordship will find the order dated where subsequent question of law has been framed. First question of law is whether a finding of the appellate court so far as the issue number 5 is concerned the purpose regarding title of the plaintiff on the face of the judgment and decree passed by the title suit number 618 exhibit 4 and 5. Whether the finding of the both learned court below with respect to the issue of limitation or purpose as same or decided without taking into consideration the materials on record. Appellant shall be liberty to raise any other subsequent question of law at the time of hearing. It was passed on 6/3/17. Before starting of the case, Lordship, may I state a brief fact of the case?
yes, yes.
Plaintiff have to file the suit because, Lordship, the defendant number, the respondent number 1 group has filed a suit against the defendant number 2 group, respondent number 2 group, under the Urban Rent Control Act for ejectment on the grounds of defaulter and bona fide requirement.
Appellant filed the suit.
No,
against-
no, not appellant. Respondent number 4 and 5. There is a suit between the respondent number 4 and 5.
4 and 5.
Respondent number 4 has filed a suit against respondent number 5 group.
5 group.
5 is a group of person. These are Montu Saha's family. They have filed a suit under the Urban Rent Control Act for ejectment on the ground of defaulter.
Okay. 4 group has filed
Suit against respondent number 5 group.
against 5. Okay.
On the ground of defaulter. In that suit, after knowing the facts, that suit premises belongs to me. There's a collusive petition suit filed between the respondent number 4 and 5. I filed an application for impleadment. That impleadment petition was rejected by the learned trial
No,
court.
a subsequent suit has been filed. First suit was for ejectment suit.
Ejectment suit.
Thereafter,
Thereafter, Lordship, I have filed an application for impleadment.
in ejectment suit,
In the ejectment suit, because the suit premises belongs to me and the rent where suit premises belongs to me. That is why I filed an application for impleadment.
okay, impleadment, then Any your difficulty?
Your Lordship, actually, my learned friend has mentioned this matter. I have not prepared the case,
Lordship,
Lordship.
my part will take the whole.
Evening, Lordship.
Whole evening, all
Yes,
remaining time.
Lordship.
Remaining time. Because
So
Lordship,
let both side come prepared. Let her come prepared.
Lordship, case has been
Or your
mentioned by the
Lordship,
council for the respondent. That is why Lordship, I have to prepare because I cannot pray for adjournment. Generally, I do not take any
On
adjournment.
your mentioning it.
Lordship, my learned friend has mentioned. I have some difficulty today, Lordship. I could not
So
go
I have to
through,
be very careful while allowing mentions.
Lordship.
Then after vacation,
Lordship.
Lordship.
Then you suggested it.
Any date, Lordship,
Then
day after
after, let
tomorrow,
it-
after
Day after
vacation.
tomorrow.
Lordship, day after tomorrow, after vacation, if your Lordship thinks.
Day after tomorrow will be better, Lordship. Lordship, always it was earlier heard by PJ Soikia.
Tomorrow, Saturday.
It was made Padhar and thereafter, Lordship, the matter has been released from Padhar. So that
Maybe
is why
before
Lordship,
vacation, maybe not possible, because
Then let it come after vacation. Because again, that part her problem would be there.
yes.
But you appears to be prepared.
Lordship, because
We are,
They have
we
mentioned
already prepared this case, already concluded argument, Lordship, CAV, then
both of
again
us,
it came.
both of us concluded our argument, Lordship.
Okay, let it come up after vacation.
22.
Mr. S.K. Goswami.
22nd.
If possible, Lordship, before vacation, because I have to prepare always, Lordship. If possible, Lordship.
26 September.
No,
Lordship.
okay, just before vacation.
Diary. 26 September, Lordship.
These are raw cases, Lordship, understand, these are raw
Next
cases.
court.
Generally, Lordship, at the time of filing, these cases are, we have to wait for long hours.
26, your Lordship can fix as he already prepared this matter, Lordship.
26 October.
No,
26 second.
26, no, September,
September.
September.
Okay. Heard Mr. S.K. Goswami, learned counsel for the appellant, also heard Miss R. Chaudhary, learned counsel for the respondents. Learned counsel for the respondents, prays for some time for going through the matter before she addresses this court. The prayer is allowed. Let this matter be listed again
On 26.
26/9.
on 26/9
Yes, Lordship. it's a-
September.
Yes, Lordship, it's a Thursday, hearing date, Lordship.
Ultimately, it will be possible for your Lordship to dispose this matter during vacation.
During
think-
vacation.
Lordship can dispose this matter during vacation.
Then let us hear it on 3rd of October. 3rd of October. 3rd is also a hearing.
Maybe it will be a motion day, Lordship. 3rd October, before vacation.
Okay, 26. 26
26/9.
September. 26.
Obliged.
Obliged. Lordship, may I submit also? I have given the
I
judgment.
got it. Thank you. One. What is this?
I'm for the respondent, sir.
Appellant?
Absent.
None appears for the appellant on call. Mr. A.R. Karim
And I am for the respondent.
has appeared for the respondent, is present for the respondent. Let this matter be listed after puja vacation on the
Lordship,
date.
a date may kindly fixed, your Lordship. The case is pending since 2018, your Lordship. No hearing, your Lordship.
On 3rd of October.
Third?
3rd October. before
3rd October.
3rd October.
Obliged.
Lordship in 16 item, Lordship.
16.
16, okay.
Show your,
3rd October.
what is your name?
So my senior.
3rd October बिकले sir. 3rd October.
3rd October.
बिकले होता है.
No, after vacation. Let it be then after vacation.
Actually, my lord, this is, my lord, share between the brothers, my lord. Between the brothers and my lord, according to them, my lord, the land scheduled land belongs to the two brothers, plaintiff and the defendant. And they say, my lord, that their share is fallen in B scheduled land, or C scheduled land. Anyway, I only pray, my lord, RD.
Show the presence of
अगर
Hard Mr.
Present.
M.H. Chaudhary.
Mr. M.H. Chaudhary, Learned Senior Counsel assisted by Mr. P. Chakraborty. Also Mr. A.R. Karim for the respondent. Let this matter be listed after Puja vacation on a date to be fixed by registry.
No, lordship, 3rd October I'll
3rd October, you are ready?
ready.
Is it okay for?
Yeah, ठीक है. 3rd
As your lordship.
Okay, 3rd October.
October. Oblige lordship.
Me please, your lordship. Lordship, this matter was already heard earlier on 28/5/2024. If your lordship goes to that order, the entire picture will be clear.
20?
28/5/2024.
What is this?
There is a MSC appeal filed by the insurance company. The primary bone of contention is that whether the accident which had occurred on 31/12/2012 that has led to the death of the claimant, which had
No, what is the primary contention?
that whether the motor vehicle accident which had occurred on 31/12/2012 that has led to the death of the claimant on 27/1/2014. That is after a period of 1 year, 26 days.
Okay.
So once your lordship may go through that order, 28/5/2024.
Now, what it says?
Here your lordship.
50% you have deposited,
Yes, 50% at the time of admission we have
But-
already deposited.
but that is not the final order.
Yes, but your lordship will find here that the accident occurred on 31/12/2012. Thereafter, the treatment relevant papers that your lordship will find only up to June 2013. Thereafter, there is no link to establish link to establish that due to this particular accident, this death has occurred 5 months thereafter. So the
No,
treatment.
we have to go through the records.
Yes.
You are ready?
Yes. May I read the operative portion of the judgment
Yes.
at page 10?
When the accident occurred?
Accident occurred on 31/12/2012. Then your lordship will find that the
Who was who was the deceased?
deceased
Where is
was
the-
one Sulman Ali. Yes.
Where is the judgment? At
Judgment
page-
starts from page 7.
The operative portion, page 10. Exhibit 6, last paragraph.
Yes, page 10.
Page 10, last I'll read from this last paragraph of page 10. Exhibit 6.
Yes.
Exhibit 6 is a certificate given by the doctor of Chitrakuti PHC. On perusal of Exhibit 6, it is found that the deceased Sarman Ali was under his continuous treatment till his death. Exhibit 17 is a MDCT scan of brain of deceased Sarman Ali, which has been done on 30/8/2013. This date is important, Your Lordship. At Dispur Hospital, Guwahati, that is about 5 months back from his death. The MDCT scan of brain of deceased Sarman Ali reveals as follows. Small focal area of gliosis in the right temporal lobe posterior inferiorly with respective cerebral volume loss, causing dilatation of temporal horn and trigon of right lateral ventricle, overlaying small post operative bony calvarial defect is seen. There are cerebral and cerebral degenerative changes. From the aforesaid discussion, it has been established that the deceased soon after the accident until his death was under the regular medical treatment. Therefore, it can be inferred that the deceased Sarman Ali died due to the injuries sustained by him in the motor vehicle accident. The opposite party side did not adduce any rebuttal evidence. Even the OP number 3 driver of the offending vehicle who had personal knowledge regarding the accident only filed WS in the case and thereafter opted not to face the case and avoided the witness box. In view of the above evidence of the claimant side and in the absence of any evidence contrary thereto, there can be no escape from the conclusion that the accident causing injuries upon the person of the deceased leading to his death has taken place due to the rash and negligent driving of the vehicle bearing registration number so and so, which was insured with the United Insurance Company. Hence, the award was given against the United India Insurance. So, Your Lordship will find this particular certificate, that is Exhibit 6. That is in the LCR, Your Lordship will find that particular exhibit.
Exhibit 6 at page?
It's 42, madam.
Page 42.
42.
Of the LCR.
Yes.
In LCR?
Yes.
In LCM.
Yes.
That was issued on 3/2/2014.
When the deceased died,
He died on
27/1/2000.
27/1/2014. Yes.
Yes, sir.
About 1 year, 26 days from the date of accident.
Okay, what is this exhibit 6?
This is the certificate issued by the treating doctor. He says that to whom it may concern, this is to certify that Mr. Sarman Ali so and so, he had on road traffic accident 1 year back near Golpara town. Following the incident, he was treated in Dispur nursing home. He was going through some physical mental confliction like vertigo, dizziness, headache, weakness since then, for which he was under my treatment. On 27/1/2014, he died at 10 at 10 about 6 p.m.
around 6 p.m.
In his wife's residence at Chirakuti. The cause of death may be cardiopulmonary arrest. So this certificate also shows that the cause of death is cardiopulmonary arrest, not due to the accident. Because due to the accident, he has suffered certain head injuries, which your lordship had already found at page 10. This is the finding of the tribunal. And furthermore, there is no post-mortem report also to show that due to the road traffic accident, he has died. And this doctor, he was also not brought to the witness box. So this certificate also has no value because he has not proved it. And thereafter, if your lordship goes through the entire record, the trial court record, your lordship will find that the period of treatment was only up to 38/2013.
What injury he sustained?
The injuries,
Head injury.
Head injury.
Yes.
head injuries,
Your lordship will find.
page 10, your lordship will find
Yes.
the MDCT scan of brain reveals as follows. Small, some
Page 10 of
page 11 of the judgment.
no. There is no document.
Yes,
There's no document. The
in
doc-
LCR, my lord, your lordships will find page 45. That
Page,
is the discharge slip, my lord.
no. Is there anything to show that this cardiac arrest was due because of this head injury? Yes, no, you may complete your submission.
Your lordship, the discharge certificate which my learned friend is referring to, that is also pertaining to 10/1/2013. That is the discharge certificate of the Dispur Hospital wherein he was admitted after the injury occurred. So the latest injury report, your lordship will find that is that exhibit 17. That MDCT scan of the brain.
Page number?
Is also, that is exhibit 17. Yes,
55.
55.
55. LCR, my lord.
What is, this is CT scan.
Yes.
Yes, my lord. Last CT scan.
So this shows the nature of injury.
You have to explain
Lordship, some
what it,
degeneration in regard to the
whether
calvarial
this,
part.
this may cause death after 6 months or after.
That is the thing, your lordship. There is no link establishing that due to this particular accident and this particular injury, it has resulted to the death after 5 months. is some kind of
Who will
cerebral
explain?
degeneration.
Who will explain this?
My lord.
Appellant or respondent?
It is
You
their-
have to explain.
It is their
Because-
burden.
My lord. As per the exhibit 6, my lord.
After this exhibit, this is the exhibit which shows what injury you sustained.
My lord.
Now, we have to find out that whether due to the injury which the deceased sustained in accident, it can lead, whether it was the reason for death after 1 year. So whether injury was of such nature that it can lead to death after even 1 year, then the appeal fails.
If the doctor would have come to the witness box, then it could have been
No,
clear.
suppose doctor has not come, but you have the report with you. You can explain the report to the court with the help of lit books.
Yes, my lord.
But your lordship will find that the later certificate which was issued by the treating doctor, that is regarding this
Death
heart
is
attack,
due to cardiac.
cardiac
Death-
pulmonary disease.
But because of this head injury, can it lead to cardiac arrest?
Yes, there is no link to establish.
No, you have, if the appellant is able to prove it,
My lord. In the certificate, my lord, it is mentioned that probable cause, my lord. Kindly see my lord, page
Yes.
42. Again, my lord. Your lordships. Annexer, exhibit
then
6.
how you have proved that the cause of death is,
My lord, he is the Ayurvedic doctor, my lord. He is the Ayurvedic doctor. He cannot say the cause of the death, my lord.
why?
My lord, without postmortem report, cause of death cannot be dictated, determined by the Ayurvedic doctor. How he will say the cause of the death so and so.
No, that only an Ayurvedic doctor can tell how he will.
My lord,
Your lordship, regarding
this
the death-
exhibit was not disputed at the time of the trial, my lord, by the appellant side,
Which
my lord.
exhibit 16?
No, my lord, at the exhibit 6.
That is not required to be disputed also.
No, they are relying, no, they are not disputing. They are actually, it helps them. They are saying,
Moreover, the certificate says the deceased
insurance
was,
company is the appellant.
Yes.
yes, my lord.
Insurance company is saying that you died because of cardiac arrest. They are relying on this exhibit 6. If you died of cardiac arrest, they are saying your death is not a cause because of the accident.
My lord, if the patient was in continuous treatment, my lord. He was in continuous treatment, my lord.
But continuity
Just
also.
before the 6 month, 5 months back, my lord, his CT scan was done. That is your lordship has seen page number 55. That is the date 30.
No, one more submission has been made that after 30 August 2013, there is no document.
My lord, this is the exhibit 6 is the document, my lord. Exhibit 6 is the document.
So therefore, lordship,
exhibit
there is no
six-
continuity.
My lord, kindly see, my lord.
No,
Here,
exhibit 6 is, it shows that you were under treatment for vertigo, dizziness only.
that is connected to the head injury, my lord. Vertigo, headache, dizziness. This is the connected with the head injury, my
No,
lord.
but it can, whether it can lead to death.
My lord,
Because your
my lord,
claim-
head injury, my lord, patient of the head injury may be die in any, my lord, causes, any cause, because the head is the main part of the body, control the entire body, my lord. My lord, head injury patient may die.
You are done with your submission. You are
Your lordship, in regard to this my case, I have already relied in one judgment passed by this honorable court. I think the copy is there in that file.
what judgment? So
Oriental versus Junubashi.
Para?
Para 8 and 9. I'll read it once, Your Lordship. As may be seen, the main ground of challenge of the impugned judgment and order by the appellant insurance company is that the death of the deceased cannot be related with the accident. The motor vehicular accident occurred on 21/5/2006 and the deceased expired after about 7 months from the date of accident, that is on 25/1/2007. Therefore, this appears to be the sole ground to be considered in this appeal. Amongst the documents exhibited before the tribunal, it may be seen from the exhibit 4, the discharge certificate issued by the GMCH, that the deceased was diagnosed with central fracture dislocation of right hip due to alleged fall on 21/5/2006 with undisplaced tibial plateau fracture of right leg. Accordingly, the deceased was treated for his injury. The said exhibit further indicates that he was required to revisit the orthopedic OPD after 4 weeks. As advised, he revisited the hospital on 21/8/2006, wherein some X-ray were done as advised. It may be noticed that beside this, there are no documents exhibited by the claimants to show that he was being treated for the injury he suffered in the accident till he expired on 25/1/2007. The post-mortem report exhibited as Exhibit 2 contains an opinion to the effect that the death was due to hepatic failure. In addition to this, injuries were found ante-mortem and consistent with the vehicular accident. But however, it was remarked that the opinion of the treating orthopedic doctor was essential. It is further noticed that the deposition of the defense witness number 1, who was the investigating officer, reveals that the deceased met with a motor vehicular accident on 21/5/2006 and he took him to Sanjeevani Hospital, whereafter the injured was referred to GMCH. Therefore, in so far as the cause of the injury is concerned, it only appears that the same was caused due to motor vehicular accident that happened on 21/5/2006. However, in so far as the cause of the death of the deceased is concerned, that is after about 7 months from the date of accident, there appears to be no conclusive evidence to show that he expired due to the motor vehicular accident. This court in the case of Union of India versus so and so relied upon the apex court decision in Bimla Devi versus so and so held that claimants before the motor accident tribunal are merely to establish their case on the touchstone of preponderance of probability, and the standards of proof beyond the reasonable doubt cannot be applied. There is no argument with the fact that the deceased met with a motor vehicular accident, but as already mentioned herein above, the cause of his death after about 7 months from the date of accident, admittedly from the material available on records, cannot be connected to the accident. Similarly, the case of Hilaria Malong will not render any assistance to the respondent claimants, since even this case pertains to the casual connection between injury and the death of the victim. This is because this court, as already mentioned above, has found that from the discharge of the deceased up to the time of his death, the claimants have not been able to show any document to establish that there was a subsisting treatment for the injury caused due to the accident. I therefore find merit in the appeal. While coming to such finding, it is noticed that during the pendency of the appeal, the appellant was directed to deposit 50% of the awarded amount, and the same has already been disbursed to the claimants. Having regard to the fact that prior to the amendment of the claim, the deceased himself had submitted a claim for injury. Therefore, under such circumstance, I find that the ends of justice will be served if the amount of compensation already withdrawn by the respondent claimants be not recovered for them. So exactly this it is fitted in this present case. There is no link to establish that after 30/8/2013, the claimant was under continuous treatment, and that has also not been proved by the claimants by bringing the qualified medical practitioner on record. So that is my case.
Yes.
Right. I am again referring the exhibit 6. Right.
Yes, exhibit
Yes.
6.
Exhibit 6. Right, it is certified that the Mr. Sorman Ali, son of so-and-so inhabitant of
Exhibit 6 is at page.
page 42, my lord. The certificate of the Ayurvedic doctor of Chirakuti PHC, my lord. LCR, my lord.
Yes. Yes, yes.
Yes, sir.
Continue.
It is to certify that Mr. Sorman Ali, son of so-and-so, an inhabitant of village Bapurbita, Part 3, Post Office Domor, Revenue PS Bogan, District Gwalpara, Assam. He had road traffic accident 1 year back near Gwalpara town. Following the incident, he was present
He was treated.
treated in Dispur nursing home, Guwahati. He was going through some sharp, severe physical, mental complications like vertigo, dizziness, headache, weakness. Since then, for which he was under my treatment.
Yes.
On 27/01/2014, he died at an about 6 p.m. in his wife's residence at Chirakuti. The probable cause of death may be cardiopulmonary arrest. Pulmonary arrest. But the doctor, this medical officer A Ayurvedic.
No, you have to show that death was due to accident. Where is the proof? By which material you are showing that death was due to the accident?
I am not the medical expert, my lord.
No, but the claimant has to
due to
prove.
head injury, a man can die in heart, my lord, cardiac arrest. My lord. I am not medical.
Now, suppose you had head injury 3 years ago, then you died after 3 years. Can you claim? And you,
if that person
unless you can link the death to the accident, you met with an accident and your head was injured. Ultimately, you died for some different reason. What materials are there on record to show that the death was due to the
Head injury.
accident, due to the accident, or due to the injuries sustained in accident?
my lord, if the certificate, my lord, in this certificate, my lord,
In this certificate, only he says that he was suffering from dizziness, vertigo, and he was under his treatment. And it also says that later on he died probably because of pulmonary arrest.
my lord.
But nowhere it mentions that it was linked.
Yes.
And
My
their
lord.
submission is that death cannot be linked with the accident. Therefore, you cannot claim compensation for death.
But my submission is that, my lord, the deceased suffered head injury. He was under treatment of the doctor regarding head injury, my lord. That is like vertigo, dizziness, headache, weakness, that is connected with the head injury.
Any other point?
And moreover, my lord, if his continuous treatment for that disease, my lord, and we can presume that he was died.
No, suppose you are under continuous treatment, but you died because of some other reasons.
That will decide by the postmortem report, my lord. Share the postmortem due to ignorance, my lord, of the poor people. This is the poor people.
Both of you submit your written gist of argument instead of repeating that.
Yes.
Whatever you Heard Mr. S. Dutta, learned counsel for the appellant. This is item number
Item number 17, my lord.
appellant. Also heard Mr. A.S. What is your name? A.S. Chaudhary.
R Islam.
Heard Mr. R. Islam. Also heard Mr. R. Islam appearing for respondent number 1 and 3. Learned counsel for both the parties are requested to submit their brief written gist of argument. When will you submit?
Today, within an hour.
Take some time. Next week on any day.
Yes.
On 27th. On 27th, 9/2024.
Obliged.
It is your lordship.
Yes.
Lordship, matter maybe come up next week. My senior is Lex, Lordship.
Yes, Miss. Chaudhary, what to do?
It will be after vacation.
Okay, heard Mr. M. Chaudhary. I heard Miss M. Chaudhary, learned counsel for the appellant. Also, heard- what is your name?
M. Bora.
M. Bora, learned counsel for the respondent who submits that her senior, Mr.
P. Gohai.
P. Gohai, who is the conducting counsel for the respondent, is on legs in some other courts. Considering the submissions made by learned counsel for the respondent, the hearing is adjourned for today. Let this case be listed after vacation on a date to be fixed by registry.
Please, your lordship. Lordship, the engaged counsel is having some illness. Therefore, he is not able to appear before this court today.
Who is ill?
Mr. A. Lal.
A. Lal.
Yes.
I am appearing for respondent number 3, lordship.
Heard Mr. What is your name?
M.K. Dev.
M.K. Dev, learned counsel for the appellant. Also heard Miss
M. Saikia, lordship.
M. Sakya appearing for
Respondent number 3.
respondent number 3. Learned counsel for the appellant submits that the conducting counsel, Mr. A. Lal, is indisposed and therefore prays for an adjournment. The prayer is allowed. Let this matter be listed
After vacation.
after vacation on a date to be fixed by registry.
Obliged, lordship.
May it please your lordship, and this appeal is filed against the judgment in our dated 21/12/2016, passed by the learned member MSCT Golaghat in MSC case number 82 of 2014, my lord. This is an injury case, my lord. Implied judgment is at page 11.
Just a minute.
Here the
Just a minute.
Here the injured was riding a motorcycle, and the owner of the motorcycle is respondent number 2, Mukesh Agarwal. The facts of the case is narrated in page number 12, my lord, that on 12/12/2013 at about 9:50, and the claim petition is filed under section 163A of the MBR. That on 12/12/2013 at
163.
63A.
A.
that on 12/12/2013 at about 9:50 PM, the claimant was riding a motorcycle bearing registration number so-and-so from Tapan Nagar, Golaghat towards Islampur. And while he reached near number 1 railway gate, an unknown vehicle which was coming from opposite direction in rash and negligent manner, and in order to escape from the imminent accident from the said unknown vehicle, he steered his motorcycle towards the left-hand side of the road. In that process, the motorcycle suddenly dashed against the back side of a stationary vehicle which was parked at the extreme left-hand side of the road. As a result, he fell down and sustained grievous injuries on his person. After the accident, he was taken to KK Civil Hospital, Golaghat, and thereafter he was referred to Guwahati. Accordingly, he was taken to Guwahati Medical College and Hospital, Guwahati, and treated there as indoor patient for 6 days from 14/12/2013 to 20/12/2013. Here, the injured was riding a motorcycle, and he himself caused the accident, my lord.
Okay.
So, our main points in the appeal is that he was not a third party at the time of accident, my lord.
Okay.
And therefore the claim application under section 163 MBF is not maintainable, my lord. And the owner is Mukesh Agarwal, and he borrowed the motorcycle from Mukesh Agarwal, and therefore he stepped into the source with the owner, my lord. On the,
Yes.
and on this, but the only point is that the claim petition is not maintainable since the claimant was not a third party. Therefore, the award given by the learned tribunal is not sustainable, my lord. And in this regard, Honorable Supreme Court has in in 2009-13 SCC 710.
Para?
In 2009-13 SCC
Yes,
7,
paragraph.
paragraph 10, 11, 12, 13. 14 discussion was with 14, 15. Then 17.
No, what was,
What is all that? If the here it was a big that case that the deceased was driving a motorcycle which was borrowed from his.
where are you reading?
Your lordship may kindly paragraph 10, my lord. The council appearing for the appellants contended before us that the High Court erred in law setting aside the judgment and order of the tribunal as the tribunal acted within its jurisdiction in directing payment of compensation structured formula which is under section 163A of the NBF. It was also submitted that the High Court erred in ignoring the jurisdiction of the tribunal to determine the just compensation, which must be done in accordance with law and not on the basis of the pleading of a party which invoked its jurisdiction. It was also contended that the High Court unanimously held that the tribunal erred in law not deciding the claim petition as one under section 166 of the NBF. On the other hand, the counsel for the respondent has argued that the High Court rightly set aside the judgment in order of the tribunal since in order to become eligible for compensation for the loss caused due to the use of the motorcycle as provided under section 163A of the NBF, the person who has suffered the loss must be a third party under the NBF And since in the present the deceased or applicants are not the third party, therefore judgment rendered by the High Court did not call for any interference. It was further submitted that the driver is a representative of the owner. He was driving under owner's instruction or permission and is thus owner co-insurance company and not a third party. In the light of the aforesaid submission, the question that falls for our consideration is whether the legal representatives of a person who was driving a motor vehicle after borrowing it from the real owner meets with an accident without involving any other would be entitled to compensation under section 163A of the MBR or under any other provisions of law, and also whether the insurer who insured the insurance policy would be bound to indemnify the deceased or his legal representatives. There are in paragraph 13, 14, 15, section 163 and 166 was discussed. Then your lordship, paragraph 17. The aforesaid decision make it quite clear that Parliament, by introducing section 163 and the Act, provided for payment of compensation on structured formula basis by mandating that the owner of a motorcycle or the authorized insurer would be liable to pay compensation as indicated in the second schedule in the case of death or permanent disablement due to accident arising out of the use of the motor vehicle to the legal heirs of the victim, as the case may be, in a claim made under subsection 1 of section 163A of the NDA. In order to prove the claim of this nature, the claimant would not be required to plead or establish that the death or permanent disablement in respect of which the claim has been made was due to any wrongful act or neglect or default of the owner of the vehicle concerned. However, in the facts of the present, it was forcefully argued by the counsel appearing for the respondent that the claimants are not the third party and therefore they are not entitled to claim any benefit under section 163 of the NDA. In paragraph 19, Oriental Insurance Company versus Resident wherein one of us named MJ Swenso was a party, it has been categorically held that in a case that third party is involved, that liability of the insurance company would be unlimited. It was also held in the said decision that where however compensation is claimed for the death of the owner or another passenger of the vehicle, the contract of insurance being governed by the contract for contract, the claim of the claimant against the insurance company would depend upon the terms thereof. It was held in Oriental Insurance Company Limited versus the section 163 of the NBF cannot be said to have any implication in respect of an accident wherein the owner of the motor vehicle himself is involved. The decision further held that the question is no longer res integra. The liability under section 163 of the MDX is on the owner of the vehicle. So a person cannot be both a claimant as also a recipient with respect to claim. Therefore, the basis heirs of the deceased could not have maintained a claim in terms of section 163 of the MDX. In our considered opinion, the ratio of the decision Oriental Insurance Company versus is clearly applicable to the facts of the present case. In the present case, the deceased was not the owner of the motorbike in question. He borrowed the said motorbike from its real owner. The deceased cannot be held to be an employee of the owner of the motorbike, although he was authorized to drive the said vehicle by his owner, and therefore he would step into the shoes of the owner of the motorbike. We have already restricted section 163 of the NBF herein before. A bare perusal of the said provision would make it explicitly clear that persons like the deceased in the present case would step into the shoes of the owner of the vehicle. In a case wherein the victim died or he was permanently disabled due to an accident arising out of the aforesaid motor vehicle, in that even the liability to make payment of the compensation is on the insurance company or the owner, as the case may be as provided under section 163. But if it is proved that the driver is the owner of the motor vehicle, in that case the owner could not himself be a recipient of compensation, as the liability to pay the same is on him. This proposition is absolutely clear on a reading of section 163 of the NBF. Accordingly, the legal representative who had stepped into the shoes of the owner of the motor vehicle could not have claimed compensation under section 163 of the NBF. When we apply the same principle into the facts of the present case, we are of the view that the claimants are not entitled to claim compensation under section 163 of the NBF, and to that extent, the High Court was justified in coming to the conclusion that the said provision is not applicable to the facts and circumstances of the present case. Now in next, 2000.
Now, in which paragraph of this judgment it is observed that
17. 17.
no, where it is observed that
22, Milord. 21, 22.
partition to কিমান আছে?
Twenty-one, 22, and 23. Yes.
Next decision 2022 SCC 550 Miller. In that case, earlier judgment was considered in paragraph number 9 Miller.
No, now in this case, High Court, Supreme Court has observed that under 163A, owner can himself, if he is driving the vehicle himself, he cannot claim compensation.
Or
And if his driver can claim, but if the vehicle was borrowed by some other person, then he comes into the shoes of the owner. Therefore, he shall be treated as an owner, and therefore is that is the submit. I'll come to you.
This one word, my lord, representative. That word is there. I will come to that point also from another judgment.
You have this judgment.
I have another judgment showing that what is the representative, the rider is to.
No, in the me. You go through this judgment also.
My lord.
Para 21, 22, and 23 of 2009-13 SCC. 2009-13 SCC 710. What is your reply to this? Para
Exactly.
21 to, because it appears that in this paragraph, her case is covered.
But slight twist is there. my lord.
Okay, I'll come to you.
Yes.
Complete your submission.
Yes.
the next decision, Miller, in 2022 SCC 550. Heard the line,
Just a minute.
paragraph number 9.
Just a minute. Slowly, you seems to be rushing. Read because you are reading for the court. You are not reading for yourself. You have to read slowly. Otherwise, it is difficult to follow you.
Sorry.
This next judgment is
Judgment is 2022 SCC 550.
2022
2022 SCC 550.
20
20
SCC.
550.
You have given a copy of that.
That's for me.
No, I don't know.
Yes, Para.
Paragraph 9, Miller. Heard the learned counsel appearing on behalf of the respective parties at law. We have also perused and considered the judgment and award passed by the learned tribunal, as well as the influence judgment and order passed by the High Court and the evidence on record. The short question which is posed for consideration of this court is whether in the facts and circumstances of the case, as in a case where the driver, owner, and insurance company of another vehicle involved in an accident and whose driver was negligent are not joined as parties to the claim petition, meaning thereby that no claim petition is filed against them, and the claim petition is filed only against the owner and the insurance company of another vehicle which was driven by the deceased himself, and the deceased being in the shoes of the owner of the vehicle driven by himself, whether the insurance company of the vehicle driven by the deceased himself would be liable to pay compensation under section 163A of the Act. Whether the deceased not being a third party to vehicle number so being in the shoes of the owner can maintain the claim under section 163A of the Act from the owner of the said vehicle. Now paragraph 9.1. The learned tribunal held that even in absence of the driver, owner, and the insurance company of another vehicle involved in an accident and whose driver was solely negligent, the application under section 163A of the Act would be maintainable against the owner and the insurance company of the vehicle which was driven by the deceased himself, firstly on the ground that the deceased was in the employment of owner of the vehicle which was driven by him, and secondly, in an application under section 163 of the Act, the negligence is not required to establish and prove, and it is enough to establish and prove that deceased has died in vehicular accident, and while driving a vehicle, the High Court has not agreed with the same, and by the interim judgment order has held that as the claimants have not filed the claim petition against the owner of another vehicle whose driver was in fact negligent even as per the claimants, and the claim petition should have been filed by the claimants against the owner of another vehicle to seek the compensation. The application under section 163A of the Act against the insurance company of the vehicle driven by the deceased himself is liable to be dismissed. Well, answering the aforesaid question imposed in the present case, first of all, the findings reported by the learned tribunal on issue number 2 are required to be dealt with and considered. The learned tribunal framed issue 2 to the effect whether the deceased driver was driving the vehicle motorcycle bearing registration number being in employment of the vehicle owner opposite party Bhagavan Sahaya in his interest or with his permission knowledge. While answering the finding reported by the learned tribunal on issue 2, it appears that as such the learned tribunal has not at all answered the aforesaid issue. While answering issue 2, there is no specific finding whether the deceased driver was in employment of the opponent owner Bhagavan Shah or not. Even otherwise, no evidence is laid by the claimants to prove that the deceased driver was in employment of the opponent owner Bhagavan Shah. Despite the above, while answering issue 4, there is some observation made by the learned tribunal that the deceased driver was in employment of the opponent owner Bhagavan Shah, which is not supported by any evidence on record. Under the circumstances, the deceased driver cannot be said to be in employment of the opponent owner Bhagavan Shah, and therefore he can be said to be permissible user and a borrower of the motor vehicle owned by the opponent owner Bhagavan Shah. With these findings, the main question posed for consideration of this court referred to herein above is required to be considered. An identical question came to be considered by this court in Nigamma. In that case, the deceased was driving a motorcycle which was borrowed from his real owner and met with an accident by crashing against a bullock cart that is without involving any other vehicle. The claim petition was filed under section 163A of the Act by the legal representatives of the deceased against the real owner of the motorcycle, which was being driven by the deceased. To that, this court has observed and held that since the deceased has stepped into the shoes of the owner of the vehicle, section 163A of the Act cannot apply, wherein the owner of the vehicle himself is involved. Consequently, it was held that the legal representatives of the deceased would not have claimed the compensation under section 163A of the Act. Therefore, as such, in the present case, the claimants could have been even claimed the compensation and filed the claim petition under section 163A of the Act against the driver, owner, and insurance company of the offending vehicle, that is motorcycle bearing registration number 72, being a third party with respect to the offending vehicle. However, no claim under section 163 was filed against the driver, owner, and the insurance company of the motorcycle bearing registration number so. It is an admitted position that the claim under section 163 of the Act was only against the owner and the insurance company of the motorcycle bearing registration number so, which was borrowed by the deceased from the opponent owner Bhagavan Sahib. Therefore, applying the law laid down by this court in Nigamma and as the deceased has stepped into the shoes of the owner of the vehicle bearing registration number so and so as rightly held by the High Court, the claim petition under section 163 of the Act against the owner and insurance company of the vehicle bearing registration number so and so shall not be maintainable. It is true that in a claim under section 163 of this, there is no need for the claimants to plead or establish the negligence and or that the death in respect of which the claim petition is sought to be established was due to wrongful act, neglect or default of the owner of the vehicle concerned. It is also true that the claim petition under section 163 of the Act is based on the principle of no fault liability. However, at the same time, the deceased has to be a third party and cannot maintain a claim under section 163 of the Act against the owner insurer of the vehicle, which is borrowed by him as he will be in the shoes of the owner, and he cannot maintain a claim under section 163A of the Act against the owner and insurer of the vehicle bearing registration number so and so. In the present case, the parties are governed by the contract and under the contract, the liability of insurance would be for a third party only. In the present case, as observed hearing, the deceased cannot be said to the third party with respect to the insured vehicle bearing registration number so and so. There cannot be any dispute that the liability of the insurance company would be as per the terms of the terms and conditions of the contract as held by this court in Thunders as insurance policy covers the liability incurred by the insured in respect of death or bodily injury to any person, including the owner of the goods or his authorized representative carried in the vehicle or damage to any property of a third party caused by arising out of use of the vehicle. In the state, it is further held that section 47 does not require insurance for damage risks for death or bodily injury to the owner of the vehicle. In view of the above and for the reasons stated above, in the present case, the claim under section 163 of the Act was made only against the owner and insurance company of the vehicle, which was being driven by the deceased himself as borrower of the vehicle from the owner of the vehicle, and he would be in the shoes of the owner. The High Court has rightly observed and held that such a claim was not maintainable, and the claimants ought to have joined or ought to have made the claim under section 163 of the Act against the driver, owner, and the insurance company operating vehicle, so as being a third party of the said vehicle. That also held that same thing, what was held in Nigamma's case.
Anything else?
After his submission, he can hit.
My lord, this is the matter of 2011 at the Supreme Court. 2012 AIRSC 797. Here also covers the same thing, but only gets the exceptional part, where it is liability occurs or where the liability does not occur. Here in the
What is your name? S. Nath.
DK Nath.
DK Nath. Which paragraph?
My lord, 17 and 18. This judgment speaks about two things. One is onus, who have to prove that fact, whether it is liable or not liable. The second thing is that the payment part, whether it is within which circumstances someone will get the benefit or someone cannot get the benefit. If we go to the
When 163A is applicable?
my lord, 63 speaks about the hit and run matter, and this also exactly says about that hit and run. The case of the claimant is that he was riding and from opposite direction another vehicle was driving rashly. He could not control and dashed against one stone. 163 is the scheme for payment of compensation in case of hit and run motor accidents.
No, but this is not a case of hit and run.
Actually, exactly not hit and run, but due to the rash driving of that Other
Deceased.
vehicle.
Other vehicle or the deceased? In this case,
Injury is there.
now in this case, what are the facts? You hit against a
Stone.
stone,
Yes.
not against another vehicle.
That is correct.
The negligence was on your part. If on the part of the deceased, if there was some negligence.
But what I am projecting is that due to the resist and negligence driving of the other vehicle, I could not control.
Two
And it-
vehicles were involved in this case.
Not directly. Not directly means some in the dark, some vehicles were approaching. So I could not control and therefore I dashed against the stone. That other vehicle,
That fact is there,
that is there. Man.
that some other vehicle was coming.
Yes, that is there. In the petition itself. And interestingly, in the WS, they never took this part, my lord. And in the paragraph number 14, my lord may kindly come to paragraph number 14 of the WS filed by the insurance. They said that there was no and negligent driving on the part of this vehicle. Kindly come to the paragraph 14 of WS. LCR to be. That is there, my lord, in the LCR, my lord. They never taken this plea, but they are taking in before this honorable court. WS, paragraph number 14. Not during the filing of WS, not at the timing of cross-examination. Nothing is there. In my application, my lord may go through the WS, paragraph 14.
Yes.
That is already there. There is no race and negligence driving on the part of the driver of this vehicle. That is me, the applicant. So how could they deny their own fact? First of all, that is one to be decided.
No. Their main case here is that if you borrow a vehicle and use it, and in use of a borrowed vehicle, if an accident occur.
But who would prove that? There is no any pleading in the WS, nor any cross-examination in the now they are making these whole points. But the pleading does not support them. Neither the WS nor the cross, they have not introduced themselves as evidence, witness also.
No, but what was your case before the claim?
My lord, that is in the face of the judgment itself, page number 12, the fact is there. My petition also that is there. May I read, my lord?
Yes. What?
Fact is this, that on
You are
12th of
reading the judgment.
my lord may go through the my claim petition also, and in the judgment is also that part is there, that it is not my fault. Some other vehicles were approaching. Page 12. Internal page 2, I think, judgment. Second para
Page 12 of the
the appeal, memo of appeal.
Yes.
Second paragraph. That on 12th of December 2013 at about 9:50 p.m. the claimant was riding a motorcycle bearing registration number this from Tapan Nagar Golaghat towards Islampatti, and while he reached near number 1 railway gate, an unknown vehicle which was coming from opposite direction in rash and negligent manner, and in order to escape from the imminent accident from the said unknown vehicle, he steered his motorcycle towards the left-hand side of the road. In that process, the motorcycle suddenly dashed against backside of stationary vehicle. Sorry, not against road, vehicle, which was parked at the extreme left of the hand side of the road. As a result, he fell down and sustained grievous injury on his person. So I have shown this to rebut this claim. That statement is not there in their WS.
On the other hand, they are admitting that there is no race and negligent riding on my part. So how could they take a ground now in the appeal stage if there is no pleading in the MSc case? First. Second is that during the cross examination also, my lord may go through, there is not a single question regarding that. Third is this, my lord, this judgment. It states there, if you rebut something, if you are claiming something, it is your duty, means insurance duty, company's duty, to prove that fact. It is not the duty of the part of the claimant. The judgment of title of the head note, judgment I have page 2. C, the head note, may I read, my lord?
Page 2.
Of the judgment C, para C. This is the head note actually. I am coming
No,
to
you
the.
come to the main paragraph.
Okay. Para 17, my lord, page 15.
Yes.
Having recorded our conclusion herein above, it is essential for us to determine whether or not the compensation awarded to the claimants
Para
respondent.
17.
Para 17, page 15 of the judgment.
Just a minute.
Having recorded that part. Page 15, my lord. Para 17.
Yes.
Having recorded our conclusions herein above, it is essential for us to determine whether or not the compensation awarded to the claimant's respondents in the present controversy by the tribunal, as also by the High Court, it is liable to be set aside on the plea of negligence raised at the hand of the petitioner. The award rendered by the tribunal, as also the decision of the High Court in favor of the claimant respondent, is therefore liable to be reappraised, keeping in mind that the conclusion recorded by us. In case the petitioner can establish having pleaded and prove negligence at the hands of rider, CISO, that is the name, the petitioner would succeed. The pleadings filed before the tribunal at the hand of the petitioner are not before us. What is before us is the award and tribunal dated 19th April 2005. We shall endeavor to determine the plea of negligence advanced at the hands of the learned counsel for the
No, before
petitioner.
that, no, in this case, whether the motorcycle which you used was your own motorcycle.
No, well, the owner is the opposite party number 2.
You have borrowed it from the owner.
Exactly not. There is no pleading regarding the borrower or representative or agent or whatever that may be. That part is not there actually. And they never endeavor to make that part clear also. And this
Then
judgment.
in what capacity you were driving that vehicle?
To that extent, my lord, we can use the word borrow also.
No, if it is borrowed, she's saying that she has cited judgment that then 163A would not be applicable.
That is what I am coming, my lord. Now the para 19. 17, page number 17, last page.
Yes.
To substantiate his second contention, it would be essential for the petitioner to establish that CISO, having occupied the shoes of the owner, cannot be treated as a third party. Only factual details brought on record through reliable evidence can discharge the aforesaid onus. During the course of the hearing, despite our queries, learned counsel for the petitioner could not point out the relationship between CISO and the owner.
No, that is what I am querying. But you are admitting that you have borrowed it.
I'm saying that there is not a single word in the pleading, whether it is a borrowed or it was a representative part or agents. There is no pleading. I'm not saying anything from my own.
Okay, neither it was brought out during cross-examination of.
That is correct. And that was what I am saying, that it was the duty of on their part. And they are themselves admitting that there is no rash and negligent driving. My lord, thereafter, CISO is not, sorry. During the
Yeah.
course of hearing,
Yes.
During the course of hearing, despite our queries, learned counsel for the petitioner could not point out the relationship between CISO and the owner of the motorcycle involved in the accident. CISO is not shown to be the employee of the owner. He was not even shown as the representative of the owner. In order to establish the relationship between CISO and the owner, the petitioner insurance company could have easily produced either the owner himself as a witness or even the claimants themselves as witness. These or other witnesses who could have brought out the relationship between the owner and CISO were not produced by the petitioner hearing before the tribunal. The petitioners has therefore not discharged the onus which rested on each soldier. So in this case, petitioner is the National Insurance Company Limited. So Supreme Court is saying that the onus is on the petitioner, means insurance company, to bring these facts. And we know that in the appeal stage, new facts cannot be brought. Since the relationship between the CISO and the owner has not been established, nor the capacity in which he was riding the vehicle has been brought out, it is not possible for us to conclude that CISO, while riding the motorcycle on the fateful day, was an agent, employee, or representative of the owner. It was open to the petitioner to defeat the claim for compensation raised by the respondent by establishing that rider CISO represented by the owner and as such was not a third party. In terms of the judgment rendered by this court in Oriental Insurance Company Limited case,
If he is not a representative of the owner, then he may be regarded as third party.
That is correct, my lord.
If he is not a representative of him.
Now, if we go to the judgment produced by them of 2009, there is a paragraph, my lord, paragraph 19. It states about the 147 policy. What are the requirements?
Act only.
Judgment of 2009, madam.
Yes.
Para 20.
Yes.
The policy 147 policy is there.
Para?
Para 20, little bit lower. Requirement of the policies and limited of liability. That part is there, madam. 147. Requirement of policies and limits of liability. That part is there.
You are looking at some other.
I'm taking from the
Supreme today.
That same judgment, I think.
But the paragraphs are not telling.
Oh, judgment to come 2009. In this judgment, matter 26.
Para 26.
Para 26. Online, it is shown as 20. 26.
Yes.
147, requirement of policies and limits of liability. In order to comply with the requirement of chapter, a policy of insurance must be a policy which is issued by a person who is authorized insurer, and this part is there. And second part is, my lord, A, B, Roman 1, 2. Thereafter, word is there, provides that a policy shall not be required my lords.
Yes.
Roman 1, to cover liability in respect of debt arising out of and in course of his employment of the employee of a person insured by the policy or in respect of bodily injury. So in this case, the employed person during a course of employment is not covered. So in this judgment given by me also, that part is there.
Okay.
Sustained injury by such an employee arising out of and in the course of his employment other than liability arising under Workmen Compensation Act, because it would cover Workmen Compensation Act. So judgment provided by me also states there, whether I am a representative or agent, if that part is not presented by them, the whole onus is upon them. And in
And your submission is that from record, it is not clear that whether you were engaged, you were representative, or you borrowed it. What is clear from record that the vehicle was not yours, your vehicle.
that is correct.
Vehicle was of respondent number 2.
Yes.
And then from where they are saying that you borrowed the vehicle.
That is correct. And whatever ground.
And whether the tribunal made such an observation that you borrowed the vehicle.
No way. Not at all. And first point, if I reiterate, my lord, if one pleading is not there, how could anyone take it as a ground in appeal? Because appeal comes from the pleading or grounds or point from the records in the matter, MSC case. That's all, my lord.
You have to give 1-page written gist.
I will not.
You have any answer, or you can give the gist of written, not big.
Just legal point.
1 or 2 pages. Heard Miss S. Roy, Learned Counsel for the appellant. Also heard Mr. D.K. Nath, Learned Counsel for respondent number 1. The counsel for both the parties are requested to submit brief written gist of their respective arguments on the next day to the court master. When?
Prior to vacation?
Your document fixed it on 27 or 28.
Let this case be listed.
27 would be better.
Let this case be listed again on 27 September.
The amount is very less, 80,000 only. Against that, they
Point of law is involved in.
Yes.
always.
In judgment bill একেলগে রাখা। What is the method?
Lordship, this is an appeal, Lordship, filed by the insurance company. Where Lordship grounds for that, Lordship, this DL is there, Lordship, DL on receipt of RTA information, Lordship. We found that the deal was fake, and accordingly, Lordship, someone was issued. And Lordship, the DTO, the learned member issued the summon, and it did not appear again. Another summon was issued, and ultimately bailable warrant was issued, then non-bailable warrant was issued, Lordship. And ultimately, he has filed the report along with an affidavit, evidence on affidavit, Lordship. Lordship will find that in the judgment, nowhere it is stated the entire order. It is not at all considered, Lordship, by the learned member.
No,
Not at all
whether
mentioned.
ultimately, whether you prove before the tribunal that driving license was fake.
That
You are submitting that efforts you made,
Yes, Lordship.
but after efforts, whether you proved or not.
Proved, Lordship, proved so far as proved is concerned, Lordship, that is, we are on tribunal issued all these summons, Lordship, and how the person is not coming, Lordship. person is not coming before that in spite of warrant was issued. But lordship, the learned tribunal not at all discuss all these things. Simply saying that they failed to prove and ultimately award was granted against us, lordship. And in this round, one judgment is also there, lordship, that is not, that proof is not necessary, lordship, because it is the entire duty of the entire work has been done by the learned tribunal.
Inquiry.
This is the decision, lordship.
No, then let us,
Then another point,
how much
lordship,
time will you,
it will
eh,
take some time.
time now?
lordship.
Now we don't have time now.
No, my lord, I could get that.
Yes, lordship. After vacation, lordship.
My lord,
Because within 15 minutes,
no, it's
It will
it's
be
not
not
possible. My lord, in
possible.
fact, my lord, the matter
because we
is,
have to go through the facts.
yes,
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 lordship.
but then,
Gist, she has stated that effort was made, but effort failed, and the tribunal said that you failed to
right,
prove your plea. She is saying that tribunal has not considered
Not
the
even
efforts
mention, lordship, not
mentioned.
even mention at all regarding our effort.
I will only pinpoint only one thing.
Your honor,
I am the owner.
Owner.
Because
Yes.
only on that point, I will not address on quantum at all. If your lordship.
not
kindly-
today, not today.
No, I'm just pointing out since
Huh.
she has raised one question. The order dated,
No, I have to say something.
order dated 12/6/2020.
What it says,
Of the LCR.
what it says.
The Learned Defense Counsel verbally submitted that he will not produce defense evidence. Accordingly, defense evidence is closed.
Yes.
They have given up.
Even if me, how we have tried, which is learned
Okay,
tribunal
okay,
has
wait.
taken steps, lordship. How we can.
So this is the point to be
bring it.
decided.
Yes, lordship. And exactly the decision is there, lordship.
Okay, we'll fix it. When should we fix it? After vacations.
Lordship.
Heard Miss M. Chaudhary, learned counsel for the appellant. Also heard Mr. S. Dutta, learned senior counsel, assisted by Miss S. Mushahari for respondent number 1. Respondent number
Yes.
1. As well as Mr. G. Jalan, appearing for respondent number 2. This appeal could not be heard today due to paucity of time. Hence, let it be listed again after vacation on a date to be fixed by registry.
if your lordship, my lord, we can get a date, it will be
No,
easier.
it is difficult because I am fixing. If I start fixing dates, the result is not very good. So let it be registry.
My lord, in fact, the matter is very small. My learned friend, the ground in the appeal is that the driving license is fake. In that case, my lord, she has no business with us. It is her statement between the owner and the, insurance company. And the law is well settled by Sharan Singh's case, my lord. That is said, if the license is fake or whatever it is, that party should not suffer. So therefore, her appeal in that sense is not maintainable at all. On that point, if your lordship decides, it's very easy, and I don't think there will be any. And I have given her a proposal. I have filed a cross objection also. My
In
lord,
this
if-
case,
And I will not press the cross subjection if the already 80% of the awarded amount has been given to us. And the rest of the amount is given, we shall not press to the cross subjection because my client is hard pressed.
then
Because
try
lordship,
for a conciliation if it is
because
possible.
lordship, owner is before us, lordship, here, owner is representing lordship. So owner is liable to pay compensation, lordship.
You have to establish.
Definitely will start. this.
Anyway, since your lordship, we
Will-
cannot take it
To
today.
convince your lordship.
Okay, after vacation, after
Lordship.
parade.
My lord, in earlier case, I was tempted to say one line. My lord, the concept of the liability of the insurance company is that, my lord, the
Under
insurance.
143.
140, 147. The insurance company insures the liability of the insured, not the insured. So now
Yes, liability of the
liability of the insured
insured.
as contemplated in section 147.
So owner is insured.
Owner is insured, and for his negligence, anything happens, in that case, insurance company is not liable. That is the decision my learned friend has cited. And that point is well covered. It is holding the field even today. So under that circumstance,
No, but for that, the whether insurance company has to prove that the person who died was a representative of the owner.
it's not required, my lord. There is a judgment of Honorable Justice Shurana that has been clarified there.
How?
My lord, whether it is borrowed or not, my lord, these things are not required because the person, supposing she is the owner of the vehicle, I have taken her vehicle, and any incident occurs and something happens due to my negligence, I am not entitled, I cannot get any, my lord, anything because my liability is insured, not if anything happens for my any sort of
Yes.
negligence, that is not covered by the policy. And that is
And
holding the field
liability is only towards others.
towards the third party. So 147, it has been clarified there. And the decision of the appeals court of this
But
one.
other side has shown a judgment.
That will not cover, my lord. I'll place that decision of Shurana's, my lord, I'll give it to your lordship.
Yes.
That has clarified the thing.
Okay. Try to give that
My lord, please.
citation of that.
Right, I'll give.
Mr. Blind.
So today, we may not be able to take up any other matters. Because only hearing matters are there.
Your lordship.
My item is item number 28, your lordship.
28.
Yes, lordship. It was, I am not, for today, I am not submitting.
Then it has to come up
After puja, after vacation.
after puja, but we are not fixing dates.
Lordship, maybe it may be November, lordship.
November.
Because here I got no award. In a death case, the claim is dismissed. Your
Okay,
lordship.
heard Mr. B.K. Jain, Learned Counsel for the item
Appellant.
20. Learned Counsel for the appellant. Whether respondent side is there,
Not there.
let this matter be listed for hearing in the month of November.
Yeah, may I please, your lordship speak, speak the item number 21 as part heard.
Yes, it is item number 27 part of yes.